Good evening, classmates. I hope all is well with everyone. For our last discussion board, Dr. Thompson tasked us with attaching a short video uh, discussing the legal cases that we discussed and wrote about for this course that involved our profession. Uh, Throughout the course, I have discussed various cases that involve my profession, which is a juvenile probation officer. And the three that I chose to talk about in this video was JDB versus North Carolina, uh, Mailman and May versus the City of Westbrook, and last but not least is going to be the new legislation uh, that involves 17-year-olds being tried as juveniles and also being housed in juvenile facilities. This is brand new to us, so I'll go ahead and start with that one first. Like I said, the new legislation that will allow 17-year-olds, to be tried in juvenile court and also to be housed in juvenile detention centers is new to us. It hadn't been uh, put in place just yet, but it's on its way. It'll be happening real soon. And with this new legislation, it brings great concerns for juvenile detention centers and also juvenile justice agencies everywhere. Uh, some of the great concerns with this new legislation is that obviously with housing with now housing 17-year-old offenders, that will bring an increase in our offenders in our detention center. With that increase, we will need to increase that detention staff as well, and without that increase in detention staff, that will cause a great concern for safety, not only the safety of the offenders, but also the safety of our detention staff and also the public. Um, Also, another concern with that is going to be 17-year-old kids being housed with some of our younger kids who are in the JDC, the 10-year-olds. That causes great concern with bullying uh, and so forth. These older kids being, mixed in with these younger kids. That's seems to be a recipe for disaster to me. But that's a great concern. Uh, that's two of the main concerns I have with that new legislation, an increase in offenders, and also uh, mixing much older kids, 17-year-olds, with the younger kids that we have, 10-year-olds. Second case I'll be discussing is going to be the JDB versus North Carolina. Basically, this case was about a 13-year-old special education student who was pulled out of his class in North Carolina by a police officer who wanted to question him in reference to recent burglaries in the neighborhood. Um, the questioning lasted for 30 to 45 minutes, and the questioning took place with school administration, the principal, assistant principal, police officer, and also a detective. But during this questioning, at no time uh, was the juvenile JDB read his Miranda rights. Uh, Even when he eventually confessed to having involvement in dealing with the burglaries in the neighborhood, he was grilled and grilled and grilled for, like I said, 30 to 45 minutes. And basically, he was under pressure to basically come forward. Um his parents were not aware, his parents were not present. And uh, first, JDB had denied having any dealings with the recent burglaries. However, an assistant principal uh, told him repeatedly to tell the truth, and he eventually JDB did inform the police officer and the detective that he had dealings with the burglaries. He was involved, and he was responsible. Now, after he admitted to doing so, he was let go. Um, but this case uh, led to him being charged with breaking and entering and also larceny. Uh, but however, the juvenile's public defender argued on his behalf uh, that while he was being questioned, he was basically in custody while being interrogated, and that the police failed to read him his Miranda rights. Uh, he eventually won that, and the charges had to be dropped. This reminds me of a recent incident we had at my job where a coworker of mine, uh, he had a juvenile probationer who was on probation and had recently uh, violated his probation because he had broke into a vehicle and stole that vehicle. My coworker was informed by Lake Charles Police that what was going on and what had happened prior. My coworker had no idea. So police called him and informed him that what was going on and that they had no luck in reaching the juvenile and no luck in you know making contact. So my coworker informed the police that he already had uh, uh, an office visit scheduled for the very next day that had nothing to do with the new charge. So while the juvenile and his mom came for the office visit, he informed the police that he would go ahead and make the arrest. Now, with us, with juvenile probation, we rarely make arrests. Very rarely. We really don't do that. We leave that up to police officers. This is the first time I have witnessed it with my own eyes and assisted. So when the juvenile and his mom came for an office visit, we uh, we separated the two. We had mom stay in the front lobby while juvenile came to the back, and he thought it was regular protocol. He thought he was just coming in to speak to my coworker, his probation officer. He thought he'd be drug tested and eventually let go. But we brought him to our conference room, and in the conference room was myself and a few more coworkers, and also the manager of field probation. And I guess he kind of got the idea that something wasn't right. So we sat him down and explained to him what was going on. The manager of probation had informed him that he was wanted and that he had a new charge and that he would be taken in. The supervisor immediately told the juvenile of his rights uh, without hesitation. So that reminded me of this JDB versus North Carolina incident. Uh, the difference was my supervisor made sure to read the juvenile of his rights. Last but not least, it's going to be the mailman and May versus City of Westbrook. Now, this case was a bit interesting to me. Uh, it basically involved two female police officers in the city of Westbrook who filed a lawsuit because they were discriminated against by uh, the police department because of their sex. And I have great respect for female police officers. It's a tough job for anybody, but to be a female uh, on the force, that's tough. So hats off to them. But it all started basically uh, because one of the female police officers pulled over a co-worker's girlfriend, another police officer. She pulled over his girlfriend, and that led to her issuing a citation. And then from there, um, they experienced all type of hate, all type of uh, foul language, and referring to them. Uh, every everything in the book. It was just ridiculous. Uh, Also, they weren't able to obtain overtime like the male officers were. Uh, they received much different treatment than male counterparts. Like I said, they were denied to receive overtime pay. Uh, let's see. Yes, that was basically it. What I had written down. Uh, they actually won their lawsuit, and uh, each each mailman and maid, the female police officer, each received $30,000 each. So justice was uh, was done with those. So I was happy to hear that. But another good thing that happened was the city of Westbrook eventually hired a new chief of police, Miss Shanine Roberts, who is a female. And since that hiring, more female officers uh, have have been hired on the force, and it says that they have been treated much more equally and with much more respect. So kudos to the new chief there and to the new system she's trying to input. Uh, they deserve just as much respect as a male officer. They're both serving and protecting their community. Like I said, these were the three cases that really caught my eye for this course. JDB versus North Carolina, Mailman and May versus City of Westbrook, and also the new legislation involving 17-year-old offenders being tried as juveniles and also being housed in juvenile detention centers. Uh, Thank you guys. I enjoyed it, and have a good evening. Have a blessing.